Hey there, Judge Evans here with a supplement to what I posted yesterday on Facebook regarding Rule 12.285 of the Family Law Rules of Procedure. This is what it looks like. I created this. And this is meant to assist people who are self-represented and don't quite understand what this whole concept of mandatory disclosure is. Mandatory, well, I'm sure you can figure out that means everybody's got to do it. Except if you're going through a simplified dissolution of marriage. You do not have to file mandatory disclosure. You do not have to file family law financial affidavits. You can if you want to. They are not required. Even if you enter into a marital settlement agreement, you do not have to file that financial affidavit. Okay, so under 12.285, what is required? Well, the financial affidavit is required. File it, fill it out. We'll fill it out first and then file it and send a copy to the opposing party. Anything that you file in the court file, the opposing party needs to get a copy of. If you are using the portal, the e-portal, Florida's e-portal, which you can, if you are self-represented, you can create your own profile on the portal. And just like the attorneys are required to do, you can file everything electronically and then copies will go from the portal to the opposing party. Okay. So you're going to do your financial affidavit. That's the first thing. And then you're going to gather all these documents. How do you know what you have to gather? You're going to read Rule 12.285. Not sure where to find it? Well, go to my Judge Mary Evans Facebook page and then follow the link. I put a PDF on Facebook. So you can't follow a link from a PDF, but I put the actual links above the PDF. So you can follow those links. So read the rule. It is not that difficult. Read the rule. This is an overview of what you are required to provide. These are very common things. 3 years of federal income tax returns, your W-2, including your W-2s, pay stubs, deeds, leases, bank statements, investment accounts, promissory notes, your credit card statements. That's something in a dissolution case we have to figure out. What's the marital debt? Any premarital agreements? All right, read the rule. And then what you're going to do is you are going to print yourself a certificate of compliance with mandatory disclosure, and you are going to check off each of these things that you are providing. And one thing that's very important, if it's in your name, you have the ability to get it. If the statements are electronic, for example, if your bank statements are electronic, go online and print them. If you have a retirement account through Merrill Lynch and their quarterly statements and you don't have the statements, call Merrill Lynch or go online and print them. You need tax returns, you don't have them, call the IRS. This is in your power to get, and if it isn't, if for some reason there's an account in your name and you cannot get these statements, then on the certificate of compliance, you might want to note why you can't get them. But just to come in and say, I don't have it, is not a good reason. It's not going to work in front of a judge. So what you're going to do is you're going to gather all those documents and you're going to make copies. And then you're going to complete that certificate of compliance with mandatory disclosure and check off each thing. Don't just check off a financial affidavit. You must have something in that list that you can provide. You're not working, then you need to be stating why you're not working, but that'll be on your financial affidavit, not on the certificate. It can't hurt if you don't have something to put on the certificate of compliance why you don't have it. Put a second page. You could say, see page 2, and explain why you don't have something or why you can't get it. So you're going to complete your certificate, and the certificate only is going to get filed. Now, if you do a page 2 explaining something, why you don't have something, that's going to get filed too. The copies of the documents do not get filed in the court file. Do not file your bank records, your IRS documents. Do not file any of these documents in the court file. Only the certificate, the completed certificate, gets filed. You are going to provide the other party, the opposing party, with a copy of the certificate and a copy of the documents. Keep copies for yourself so you know what you gave, and then accurately check off what you are providing. So it's a good record of what you sent. Generally, you are not going to file those documents in the court file, ever, unless a judge instructs you to do so. Again, this is an overview. This is designed to lead you through this process. If you need, if there are any questions, go to the rule. Look up 12.285, follow the link, and see if you can't answer your own question. The judicial assistants and the clerks cannot answer your questions. Regarding procedure, the case manager assigned to your case probably can help you with the procedure, just like I'm helping you right now with procedure only. If you have any other questions, contact an attorney, because only an attorney can give you legal advice. I hope this has been helpful, so keep watching my YouTube channel and my Judge Mary Evans Facebook page for more hints